If you've ever been sued, you ever been in court, you know what to do. And if you haven't, I'm going to help you figure out what not to do by using Johnny Depp and Amber Heard in one of the most ridiculous cases known to man. Let's jump into it. What I'm going to do is I'm going to use clips from the Johnny Depp and Amber Heard trial to teach you about classic screw-ups that people are making in this trial and that a lot of people make every time they get sued. First and foremost, anytime you go into any kind of deposition or any kind of litigation, you need to know you shouldn't elaborate. It should be yes, no, I do not recall to the extent that you can. And if they ask you a detailed question, you answer it swiftly and clearly, but don't elaborate. And I'm about to show you why.
You dipped your finger in paint after suffering an injury.
Yes.
Yes or no?
Yes, that was after after writing on the walls, the blood had kind of dried, as it were, and so I stuck my finger into a can of paint and also, excuse me, mineral spirits to put my verbal messages onto the wall.
You'd agree with me that there was quite a bit of damage to the house in Australia after this incident, correct?
There was quite a bit of damage to the house during the entire incident, yes.
And you don't remember the television breaking, do you?
I remember there was I believe there was a coffee cup stuck into the screen, or a plate or something like that.
So as you saw in the video, Johnny Depp is taking his time and he's elaborating a whole lot on a set of circumstances. Most notably, he's talking about dipping his finger and drawing stuff and leaving a message. That wasn't the question. The question was, did you dip your finger in paint? Explaining why, you're just giving them more fodder to ask more questions. Don't do that. And the second thing he's doing is he's explaining how there's a cup or a plate in the TV. You can just say the room was a mess or answer the question yes, or answer the question it was damaged. To go into that detail, you're giving extra detail which can be used against you and likely will be by the other attorney who's going to cross-examine you. Stop elaborating. In the next clip, we're going to talk about courtroom decorum, the things you can and cannot do, and we're going to get into why there are other people besides those who are parties to the lawsuit in court.
How many other franchise films had you been a part of?
Alice in Wonderland. Oh, I'm so pathetic when it comes to knowing what movies I've done. I'm sorry. I just, I don't watch them. I couldn't, what was the question again?
How many
order in the court, or I will have you removed.
Okay, so not all courtrooms are open to the public. So the judge has wide discretion here, which you saw her exercise. You can't go into a courtroom as a viewing guest and just laugh whenever you want to. This is a very serious atmosphere. So the judge is exercising it by telling the people in the courtroom not to laugh. She also started this whole courtroom procedure off by limiting all the selfies with Johnny Depp that are being requested and the signatures and autographs. She won't let that happen. Normally speaking, someone in Johnny Depp's position wouldn't want this broadcast in front of the world. It is a judge's decision to do that or not do that, whether to allow people in or to not allow people in. But in this case, it's a defamation lawsuit. This works really, really well for Johnny Depp. Johnny Depp wants the world to see how ridiculous this is because his argument was, I was defamed. And even if he loses this, I think the world has seen what Amber Heard is like because he's had the opportunity to speak to a world in a much broader sense. Court hearings are generally open to the public and you are welcome to attend and watch the proceedings. A courtroom is a formal setting, however, and people tend to forget this, and your conduct should be polite and respectful to the judges and the attorneys. Laughing in a situation like this is completely inappropriate, and the judge was within her discretion to say, if you keep laughing, I'm going to kick you out. So the next clip is also a fascinating one because we're getting into objections and hearsay. To give you a little bit of insight into what this means is that there are lots of different things you cannot do and say in court, just like the people who are witnessing it. You as an attorney or a witness, you can't do or say or ask certain things. But this has become a huge problem in this court case because the attorneys aren't that prepared, aren't that good, and the witnesses are kind of bizarre. Let's jump into it.
I was saying that...
Objection, hearsay.
Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying?
Where was the question again?
Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without getting into what he was quoted as saying? Mr. Depp, where was Sean Bailey quoted, without
I don't know who did the interview with him.
Objection, lack of foundation.
All right, under the rules of civil procedure, there are a lot of things, like I referenced before, that you can't say. Let's break those down. Hearsay is one of the things in this trial. It's made the news. A lot of people have reached out to me. They want to know what it is. It's an out-of-court statement offered in court to prove the truth of the matter asserted. If my friend said X, I would not be the best witness for what my friend said. My friend would be the best witness for it. So you can't say what your friend said to you. In this case, Johnny Depp is trying to testify to what somebody else said. You cannot do that. So a hearsay objection is actually good. Now, that is only one type of objection. There's lots of things that you specifically cannot say in court. So certain things are specifically not hearsay. There's exceptions, all sorts of technicalities here. We're not going to get into it, but some of the exceptions you're going to hear in a couple minutes are vague and ambiguous. You can't ask vague and ambiguous questions that people don't understand. You have to be precise and specific. You can't ask argumentative questions. You can't, as an attorney, argue with the witness. You can't, get into them and get aggressive. You can't ask questions multiple times, asked and answered, and I'll explain that in further detail because there's two reasons why you really shouldn't do that, and it's happened a lot in this case. You can't assume facts that are not in evidence. Hypothetically, if this were a fact, what would you do? You can't do that. It has to be based on fact and in front of you, and that's a lot of the things that's wrong with this trial as well. You can't call for speculation, which is very similar but different in an objection. You can't ask leading questions saying, hey, you think you're innocent, don't you? That's leading the witness. You can't lead the witness. You have to ask pretty much clear and concise questions. And then, of course, you can't call for a narrative. You can't call for these long-winded answers, but don't worry, Johnny Depp has been giving that up all on his own, so you don't really have to ask for a narrative. And you can't misstate the evidence. You can't change the evidence that's in the courts, in front of the court. You have to ask things based on the evidence they have, and if you don't have the evidence for it, you really can't ask questions about it. All of these things will be objected to, and you will hear about them, and now you know a little bit about them. So one of the objections you're going to hear coming up is a lack of foundation. So to explain this, the lack of foundation means that you have asked a question of the witness before establishing a fact that must be established before his answer becomes admissible evidence. It is a fatal objection. What that really means is you can't say, I'm going to ask you a question about this thing if this thing is not in evidence or something about it existing is not in evidence. Let's see how this all plays out.
Exhibit 804 be moved into evidence and published.
Any objection?
I think it's outside the scope.
The next day I went to see a specialist, a hand surgeon, and this was still in Australia. And he had recognized that my excuse for the finger being gone.
Objection, Your Honor. Hearsay. What the doctor conveyed to him, that's classic hearsay.
So now you've been prepped. You've seen how these objections can play out, and you can see how really disturbing and frustrating they can be. Johnny Depp is clearly visually pissed off, and he has every right to be because you're trying to give testimony, explain your side of the story, and every single time you explain something, someone's going objection and cutting you off. It's hard to stop and start again, and it's really, really frustrating for the jury and the judge and everybody else in the courtroom because you're just trying to get to the bottom line, and yet you're playing through this legal process. Another objection outside the scope, you can't ask questions that are outside the scope. For example, how many sexual partners have you had? If I had $1 for every time somebody in a family law case or dispute tried to ask some question that was completely outside the scope of litigation just to find out the answers because they're under, quote, oath, it would be amazing. I'd be a millionaire. But you can't do that. And so Johnny Depp asking questions and answering questions that are outside the scope, you can't do it. Another thing that we saw come up is relevance. Relevance is a huge issue. You can object to the relevance of evidence if you think a piece of evidence or something a witness is saying has nothing to do with the case or it is not important to determining what should win in court. An example would be asking again, sexual partners. So you have to keep in mind that the attorney should be specific and clear and concise. And in this case, they're anything but that. Let's jump into the next case. There's a lot of objections coming up. And now that we've laid the foundation for what you're going to see, you're going to see how fucking ridiculous this gets.
When Amber made abuse accusations against you in May 2016, fair to say it got a lot of press attention, right?
Objection calls for speculation.
All right, I'll sustain the objection. Next question.
When Amber made abuse accusations against you in May 2016, you became aware that it got a lot of press attention, correct?
Very quickly, I became aware.
And she became associated with those abuse accusations that she made against you in May 2016, correct? To your knowledge.
Objection calls for speculation.
I'll sustain the objection. Next question.
You became associated with those domestic abuse accusations that she made against you, correct?
I think that's clear.
And you understood that she became associated with those same accusations that she made, correct? You've testified to that.
Well,
So you can see how this shit just gets really, really frustrating. Johnny Depp, again, looks more and more pissed off as time goes by. The speculation objection can be used in two different situations. First, a witness does not know a fact to be true or not, but testifies about it anyway. This testimony would be objectionable. You can object to it, but you can also let it in. A witness must have personal knowledge of a fact they're testifying to, and that has to be a prerequisite in order for it to be put in the court's record. Second, if a question that is posed can only be answered by using speculation, you can only answer it if you're coming up with it creatively, the question would be objectionable. You can object to that as well. It has to be based on facts. And that attorney had to ask the question 2 or 3 times to get the question that he wanted structured. A good attorney would have had the questions written out, and then if something went left and he had to ask questions that were different than what he had planned on his script or the direction that he wanted to go, he would be creative enough and have enough experience to ask those questions ad hoc. This is very distracting. Let's jump into the next clip.
if she wanted restraining
It's a yes or
order.
no question. You didn't try to get the restraining order.
No, why would
did you?
I?
And you didn't have a divorce trial where you could respond to Amber's accusations of abuse in 2016, did you?
Objection calls for a legal conclusion.
I'm asking him if he had a trial. That's
All
a
right,
fact.
I'll allow-
You didn't have a divorce trial where you could respond to Amber's accusations of abuse, did you?
Clearly, this has gone left once again, and now it's calling for a legal conclusion. You can't ask a witness who is not an attorney, and even one who is an attorney, to draw legal conclusions based on the evidence. That's for the jury and the judge to decide. You can't do that. So with all objections and all hearsay, the judge has two choices. They can, one, sustain the objection, keep it alive, which means the objection is valid, means it shouldn't be in the record. Or they can overrule it, meaning that your objection is not valid, I'm going to allow this to happen. In this case, the judge never really says overrule, she says, I will allow it. That's what's really happening here. So just to be clear, when a question improperly asks a witness to reach a legal conclusion, which is a job reserved for the judge and jury, that is something you can object to, which has happened here and will continue to happen multiple times. Now, speaking of multiple times, you can't badger the witness by asking them a question they've already answered multiple times. That's an asked and answered objection. And these are quite fun because you're going to see them play out right now.
You didn't have a California divorce judge decide these facts, did you?
Objection asked and answered.
I'll sustain the objection.
You chose not to try to clear your name at that time through any sort of legal proceeding, correct?
Objection asked and answered.
I'll sustain the objection.
And you chose to sign a divorce agreement in which you stated that Amber had not made any false statements about you for financial gain. We looked at that, correct?
Objection asked and answered.
Asked and answered. I'll sustain the objection. Next
In
question.
fact, you waited until Amber wrote the op-ed in the Washington Post in December of 2018 to file a lawsuit against her, correct?
That is correct.
All right. Asked and answered, like I foreshadowed. Sometimes during cross-examination, the person asking questions might ask the same question over and over again, perhaps in slightly different ways, or re-ask a question that he or she has asked earlier in the testimony. What's unique about this objection is that it could come up in two different scenarios, like I alluded to earlier, okay? And this is really important to understand. The first scenario is opposing counsel could repeatedly ask you or your witness the same question, hoping that contradicting answers will be given, ultimately that you will change your testimony. Police do this a lot. They'll get somebody in an interrogation room, they'll have a light on them, they'll shine the light there, and they'll badger them over and over and over and over and over again, asking the question until they eventually break. You certainly can't do that in the courtroom, and frankly, you shouldn't be doing that at all to anybody, because people, human behavior, they tend to give in to questions, or they eventually slip up. Second, the opposing counsel could repeatedly ask his or her own client the same question in slightly different ways, hoping that the client will come up with a better answer than the one given before. That either way, the question can only be asked once, and after it's been answered, any further attempts to ask the question are objectionable on both sides. So you can't lead the witness or ask them and go, hey, you were there, right? And they say, no. And they go, well, you were there, right? And they go, yes. You can't do that. That's objectionable. The first answer stands. Now, relevance and compound questions come up next. One of the things you've seen Johnny Depp do over and over and over here is that he's passionate about this. He's eager. He wants to get into it. What he's doing is he's giving too much information. He was literally told by the attorney interrogating him on the stand, it's a yes or no question. And frankly, he should be answering yes or no and let his attorneys ask the questions that really matter that he should elaborate on. But let's get into compound questions, which this attorney screws up and actually does.
You chose not to sue the Washington Post in this lawsuit, correct?
Objection relevance asked and answered.
It's not been asked and answered.
Hasn't been asked and answered, but I'm not sure what the relevance is.
You chose to sue only Ms. Heard and not the newspaper that published this article, correct?
Objection compound.
All right, I'll sustain as to compound.
You chose not to sue the Washington Post, correct?
Objection relevance.
I'll sustain the objection.
You only sued the author of this article, Amber Heard, correct?
Which seems she was the one making the statements. Yes, I had the opportunity to fight back.
All right, so there's that ugly relevance objection once again, and now you see the compound question that I was talking about. A compound question is when two or more questions are combined into one question. Compound questions are not allowed because they can confuse the witness, the judge, and the jury. Also, it may not be clear for the court recorder of the questions being asked, right? So there is somebody who's actually taking a written record of all things that are asked, and last thing you want to do is ask compound questions and confuse things. You're going to see how this becomes problematic in that the answers that are given by the witness on the stand will be all over the place. It'll be one answer here, one answer there. They may answer the first question, not answer the second question. So the last thing you want to do is give someone like Johnny Depp that opportunity anyway, because he's going to be all over the place and he's not going to answer your question entirely for sure. So if an attorney finds himself asking a compound question, they typically get flustered with the other party's objection and skip the issue entirely, or they just separate out the question and ask one question at a time. This attorney struggled with that, and clearly there's frustrations on both sides. It's probably not fair to call him a bad attorney, but what I will say is he goes right back into calling for a legal conclusion in the next clip, and this clip is the last clip of legal bullshit I'm going to give you, and then I'm going to give you something really awesome to send you on your way with.
Mr. Depp, you realize that the only job for this jury to decide,
Yes, sir.
its only job, is to determine whether this op-ed and this op-ed alone is defamatory.
Objection calls for a legal conclusion.
I'll sustain the objection.
This is the only writing that's the subject of this lawsuit that you brought, correct?
Same objection.
It's fact, Your Honor. He
I'll
only brought the
allow
lawsuit.
that question. I'll allow that question.
This is a version of that story of the op-ed that I've never seen. The one that was published before, the only one I've ever seen is the one that was published prior to this. They changed the title because they were in fear of trouble.
Well, I'd move to strike that last testimony, Your Honor.
Well, I mean,
So the motion to strike or moving to strike would actually remove part of Johnny Depp's testimony from the record. Johnny Depp said something that he shouldn't say. He said what a fact was that he speculated on. So instead of objecting to it as being speculation, he just moved to strike and the judge will allow it. So basically that statement effectively was never said and cannot be used in order to make a decision whether or not Johnny Depp was defamed. Now, before I let you go, there is one thing in court that happened that just blows my mind. It was so preposterously crazy that it makes absolutely no sense to me. And I got to tell you, I don't know how good Amber Heard must have been in bed for her to be able to do this, but this actually happened.
I had received some news that was as absurd and grotesque and cruel. And then I was shown a picture of what the problem was. It was a photograph of the bed, our bed, and on my side of the bed was human fecal matter.
So what did you just hear? Basically, Amber Heard took a shit on Johnny Depp's side of the bed, took a photo of it, and sent it to him. Now, I don't know that either one of these people are sane people or normal people, but that's crazy. So that's the kind of stuff you get in a defamation lawsuit. If you ever find yourself in one, now you know the objections you're probably going to face. And if you ever find yourself in any kind of litigation or depositions, you could face the same objections and the same type of crazy shit. Don't do something stupid, and hopefully you never have this problem.